appeal in the matter of HMRC and Bolt Services UK Ltd.
Yes, Mr. Metropolis.
My lords, my lady, I appear with Miss Brown on behalf of HMRC. My learned friends, Miss Sloane KC and Miss Lawrence, appear for the Respondent, Bolt Services UK Ltd, who are referred to as Bolt. I just start by checking the bundles are all in order. Your lordships and ladyships should have a core bundle, a supplementary bundle, an unagreed bundle relied on by Bolt with the permission of this court, and an authorities bundle.
I think so.
And the parties' replacement skeleton arguments are in the core bundle at tabs 3 and 4. And I've handed up, a clip of documents. Some of them are replacements because the authorities bundle printout had some errors, but I'll come to them as I need to, if that's all right.
Okay.
On timing, I've agreed a timetable with my learned friend by which I finish my submissions today. My learned friend stops at around 3:30 tomorrow, allowing time for a reply.
Mr. Metropolis, can I just mention the timetable? As you might expect, you have been thinking about the case, reading the material, and reading your skeletons, for which we're very grateful, and the authorities and the judgments. I'm bound to say it doesn't feel like a 2-day case to me, which is a polite way of saying you've got a day and a half. I really don't think this case requires 2 whole days of argument. I recognise it's extremely important, we all do, but it is a point of law, fundamentally, 2 points of law, and I'd be very grateful if you and your opponents can cut your cloth accordingly.
My lord, can I make this plea, as it were? I stand here having lost in the first tier tribunal and the Upper Tribunal. So obviously my point takes some explaining. And I'm going to try and support it by going under three headings, as it were, to the matter of case law. I need to look at it closely to show that the first tier and Upper Tribunal erred in their interpretation of what we say is the right test. And I was actually concerned about time, so I'm a bit worried if I have to limit my submissions further. What I'll try and do as I go along is cut if I can. But although, as my lord has put to me, in a way it's a simple case and I should be able to deal with it quickly, obviously we say the first tier and Upper Tribunal have gone badly wrong, and I can only make that good if I take it step by step and in some detail. Okay. So that's, if I could say that and do my best to
as
run
always
along.
In these cases, if you're right on the law, then it follows the FTT and the UTT were wrong. So it's all a question about what the law actually is.
Indeed.
Yeah, so I do, for that.
Well, let's
that
review it at lunchtime, Mr. Metropolis, but I can tell you now, you have not so far persuaded me that this is a 2-day case.
Okay, well,
So I'm
let's
expecting
see.
you to finish before 4:15, because I think you will be able to do that very well without doing any detriment to your client's position. We completely understand your client's position. You've explained it in great detail, fully. I'm not criticising,
No, I understand.
for explaining it in that detail. It's very helpful, actually, to have done that. And you don't need to go back through all the detail in the same detail that you've already done it. So that's part of the point. But anyway, instead of you and I debating it, let's get on.
So to give a roadmap for my submissions, there'll be in 4 parts. In part 1, I'll set out the overview of our position. Part 2, I'll run through the legislative provisions and establish some key aspects of the scheme, and in particular what we say is the right test to be applied in considering whether Bolt supplies fall within it. In part 3, I'll outline some key facts, obviously quickly, and what we say applying the right test follows from the FTT's findings. In part 4, I'll deal with ground 2. So part 1, the overview. I'll set out a position and outline now and obviously make it good in parts 2, 3 and 4 of my submissions. I should say, in light of our quick discussion just now, I'm rushing a little bit. If I am going too fast, please do interrupt.
Yep.
So first, if I could outline the supplies in issue. Bolt's a licensed regulated PH.
Sorry, can I just ask, have we got a transcript running?
No.
Okay.
Bolt's a licensed regulated PHVO, private hire vehicle operator. It supplies minicab rides to its customers, and of course such rides are in a private car. The customer uses their Bolt app to request a ride, and the ride is on demand, which means it's a request for as soon as possible to wherever the customer is, point A, to wherever the customer wants to go, all and any possible points B. Now, of course, all transport is point A to B, but minicab rides, including Bolts, are, as I say, from the point A where the customer is standing to any point where the customer wants to go, a door-to-door private car service. And as one would expect, the findings of the FTT were that Bolt acts largely in urban areas. Only some 3.5% of rides were for more than 25 kilometres, and only some 2.3% of rides were to or from airports. And Bolt uses self-employed drivers to supply those rides. Bolt knows where its drivers are when they're logged onto their Bolt app, and when the customer requests a ride, Bolt will send the nearest driver. If that driver isn't available, Bolt will send the next nearest driver. So that's an outline of the supplies and the rides, and no doubt the court is familiar with. And Bolt's always accepted that it's not a travel agent or tour operator on the ordinary meaning of that term. Sort of ruling that it could use the travel agents, the special scheme for travel agents. HMRC said no, and here we all are. And to outline the scheme, it provides that A, travel agents, including tour operators who supply travel facilities, B, who act as principal, and C, who use the supplies of other taxable persons to make their supplies, i.e. buy in and sell on, shall use the scheme. And as I'll come on to, that scheme modifies the normal VAT position in significant respects. Now, at the heart of the dispute between the parties is, of course, the question how to identify whether Bolt supplies are within the scheme. It's common ground Bolt acts as principal, so it's ticked that box. There's a dispute between the parties as to whether it satisfies the requirement of using the services of other taxable persons to make its own supplies, or whether they're in fact properly characterised as in-house supplies or materially altered. That's the subject of ground 2 of my appeal, and I'll put that to one side. Focusing on ground 1, on the question of the nature of the supplies that come into the scheme, we say Bolt supplies only come into the scheme if they're identical or sufficiently comparable to the supplies of travel agents or tour operators, giving those terms their ordinary meaning. And we say, as the FTT was not convinced that they were the same or similar to the supplies of travel agents, Bolt can't use the scheme. My learned friend's position, and one accepted by the tribunals below, is that Bolt supplies come into the scheme because they're resupplies of passenger transport. My learned friend's way of putting it is it's sufficient if there's travel and a journey. According to the first tier tribunal, it's sufficient if there's passenger transport. And according to the upper tribunal, it's sufficient if it's travel or transport. And each of those are just ways of saying it's sufficient that Bolt resupplies transport of some kind. And that's what I'll refer to as the high-level approach. And to outline the key reasons why we say the high-level approach is wrong. First, it does away with the whole notion of supplies of travel agents and tour operators that is at the heart of the scheme. We know why the scheme exists. The CJU has made it repeatedly clear. It's because the travel agent sector typically makes multiple supplies in multiple places, and the normal VAT rules would create real difficulties for that sector. The normal rules would necessitate the travel agent has to register for VAT in the multiple member states where the transport takes place or where the hotel is located. And as we say, the scheme clearly selects the travel agent sector for special treatment, as its title suggests. Of course, not every travel agent faces these problems, and other traders who are not travel agents in the scheme can face the same problems. So a trader making a supply of coach transport using its own fleet of coaches across different member states faces the very same problem of having to register and account for VAT in each member state the coach transport goes through. But it doesn't get a special scheme at all. So, as with all attempts to fix a problem, a scheme, a rule was chosen, and it identified the travel agent sector as its target and chose to exclude the wider transport sector that doesn't use the supplies of others. And it expressly set out that it's for travel agents or tour operators. And we also know why the travel agent sector was targeted, because it's repeatedly made clear by the CJU. It selected the travel agent sector because traders in that sector, quote, most frequently face the problem. In other words, the travel agent sector was selected in order to try and capture as many of the traders that needed the scheme as possible. Yes, it identified travel agents, therefore, who don't need it. And yes, it kept out other traders who might also need it. But that's in the nature of having a rule. By picking the travel agent sector, it targeted those traders who most likely need the scheme. And it's common ground that you don't have to be a travel agent or tour operator on the normal meaning of the term to use the scheme. That's been made clear in the case law, but we say that case law supports the test we identify, that supplies still have to be identical or comparable to the supplies of travel agents and tour operators to be in the scheme. In other words, travel agents remain at the heart of the scheme. Others use the scheme on the basis that like supplies are to be given like treatment to avoid distortions of competition. Now we say the
Is
high...
it distortions of competition that you're avoiding, or is it promoting fiscal neutrality? Maybe it's two sides of the same coin.
Two sides of the same coin. It's expressed in terms of ensuring uniform application of the directive to avoid distortions of competition. And usually, I'll go to the case in a moment, but it's usually the test is, are the two supplies from a typical consumer's viewpoint identical or sufficiently similar so as to compete, not actually compete, but. So now we say the high-level approach erases from the scheme all reference to travel agents and tour operators. It would be the very same scheme, according to the high-level approach, if it simply provided that any traders acting as principal and using the supplies of others to make supplies of travel facilities are in the scheme. And we say that has to be wrong, and we say it misinterprets the CJU's case law. We also say this is reason 2 why the high-level approach is wrong, that it leads to an expansive interpretation of the scheme, which is contrary to the correct interpretation of a derogation from the normal VAT rules. The high-level approach basically takes a scheme, which is for the travel agent sector and for identical and comparable supplies, and applies it to a whole sector, the whole other sector, the minicab sector, and we say that's an impermissible expansion. Moreover, it's not an expansion that's claimed to be required by the objectives of the scheme. There's no claim that the minicab sector, like the travel agent sector, frequently or characteristically needs the scheme. It's an expansion which results entirely from the adoption of the high-level approach. And as well as the high-level approach being contrary, as I say, to the case law identifying the right test and being an expansive interpretation, it's defended by my learned friend, and this is the third way in which we say the high-level approach goes wrong. It's defended on the basis that our test is too difficult to apply. And we say that's also an error, and we see something of that in the tribunal's decisions, as I'll come on to. My learned friend says, in effect, that it's difficult to differentiate, on the one hand, passenger transport supplies that are the same or similar to those made by travel agents, on the ordinary meaning of that term, and on the other hand, passenger transport supplies that are sufficiently different. And that any attempt to draw the line creates what my learned friend calls a fiscal neutrality minefield. My learned friend says it's much simpler to let all passenger transport resupplies into the scheme. That's the argument from simplicity. As regards, I am trying to respond to the nod, I'm just also
Right.
keeping an eye on the pen. So as regards the claimed fiscal neutrality minefield, the principle of fiscal neutrality holds that supplies that are identical or similar from the typical consumer viewpoint should be treated in the same way. We don't deny that principle. We say it's the very principle that supports our test, as articulated by the CJU, that bulk supplies have to be shown to be identical or similar to those of travel agents on the ordinary meaning of those terms. My learned friend will no doubt try to provide examples of a supply close to the dividing line and say, how can this supply be out of the scheme when it's similar to a supply just on the other side of the line? And that's said in an attempt to say that no line can be drawn or it's being drawn in an arbitrary way. But your lordships and ladyship will be aware that law generally and VAT law in particular does draw dividing lines between different kinds of supplies. And at the boundary line are sometimes difficult cases, which of course the courts rule on routinely. And the argument that there may be difficult cases, we say can't be put forward in favour of throwing in the towel and adopting the expansive high-level approach. And that's of course particularly so in relation to a derogation from the normal VAT rules, such as the scheme. If I'm right that the case law of the CJU supports my test, it's not open to my learned friend to complain that it might be difficult to apply in some cases. And the final related point I wanted to make in this overview is that we say this is not, in fact, a difficult case that is near the line at all. Bolt's always rightly, inevitably accepted that it's not a travel agent or tour operator on the ordinary meaning of the terms. And it made that concession precisely because there's a clear line between the supplies of travel agents and Bolt supplies.
I hesitate to interrupt, that's not the basis upon which the concession is made.
My learned friend can set out why she says she's not a travel agent in the ordinary meaning of that term, but the reason that anyone would think they're not travel agents on the ordinary meaning of that term is because we don't use travel agent in that way. I don't, when I'm waiting outside the supermarket with my heavy shopping, think that I am contacting a travel agent to arrange a minicab home. We have a different term for those operators, it's minicab operators. And importantly, importantly, Bolt failed to convince the first-tier tribunal that its supplies were the same or similar to those of travel agents or tour operators. I'll come on to them, but it's paragraphs 92 and 105 of the FTT's decision. My learned friend challenged paragraphs 92 and 105 of the FTT decision as irrational in Bolt's respondent's notice to the Upper Tribunal, but importantly, didn't pursue that challenge in her skeleton argument or at the hearing, and hasn't repeated that claim to this court. So we say paragraphs 92 and 105 of the first tier tribunal decision stand. And on the basis of what we say is the right test, the first tier tribunal was indeed able to draw the line and say bulk supplies were on the wrong side of it. Bolt nonetheless succeeded only because of the adoption of the high-level approach. And we say the Upper Tribunal adopted the same approach. It said that the high-level approach might not be absolute applicable in every case per se, but didn't set out what would be kept out of the Upper Tribunal's own understanding of the case law as there being a requirement only for a resupply of travel. So we say bulk supplies are not like those of travel agents and tour operators because travel agents, on their ordinary meaning, don't cover the areas and routes bulk does. They don't offer door-to-door particular point A to any particular point B of the customer's choosing private transport. They don't do so on demand. Those differences together aren't matters of detail that I rely on. They just look at the obvious features of bulk supplies. And no doubt were the basis of the first tier tribunal's view that bulk supplies were not the same or similar to those of travel agents and tour operators. And presumably, if those features didn't make a difference, my learned friend would have been at least tempted to argue at some stage of this prolonged litigation that Bolt was a travel agent on the ordinary meaning of that term. So looking at bulk supplies in the round, we say they're not identical or comparable, and the FTT didn't think so either. And yes, one can pick off each feature in isolation and try to identify a similarity for that feature. So my learned friend asks, how can it be that a ride to an airport is in the scheme, but a ride to an address near the airport is outside the scheme? Of course, we say all minicab rides are outside the scheme. But even if that were wrong and airport rides are in the scheme, they're in the scheme because they are similar or identical or similar to supply to airport transfers that my learned friend says tour operators make. And as I say, Bolt failed to establish they are the same or similar for the FTT, and the FTT found direct competition with other PHVO operators, unsurprisingly. And Bolt failed not because it didn't produce empirical evidence of actual competition, but for the common sense reason that travel agents on their ordinary meaning simply don't do what Bolt does or anything like it. As I say, I'm standing outside a nightclub at 4 a.m. Yes, I might be able to book a last-minute hotel room or book a flight the next day to Spain. But what I can't do is contact the travel agent or tour operator on the ordinary meaning of that term in order to book a minicab ride home or to whatever destination I want to go to. Travel agents simply don't help me. It's the separate minicab sector I look to for that. And as we'll see when we come on to the tribunal's decision, the first tier tribunal didn't single out airport transfers as being sufficiently the same or similar, but it did, when looking at the characteristics, say, oh, but when travel agents supply airport transfers, that's also potentially private, but in any case, a door-to-door service.
In most cases, that would just be a pure ancillary supply anyway, wouldn't it?
Precisely. And I'll come to the Minerva case, which sets out that even if they were opera tickets, an ancillary supply would come into the scheme as long as it's not in-house.
If you'd sold the package, including the opera tickets, the opera tickets are ancillary.
Precisely. But even if I can just make it clear, because we say that the tribunals fell into error here, even if I'm wrong and the airport rides, despite the fact that they're not being packaged and so on, somehow have sufficient similarities to the travel agent sector to come into the scheme. What one can't do is say, therefore, they're all in the scheme. So imagine if the 2.3% related to the traders' supplies in this sense. So you have a minicab operator who makes 97% supplies of minicab, regular minicab rides, and then for 2.3% of its supplies, it's actually buying and selling flights. Now, obviously, you might say for those flights, we see the similarity, they're in the scheme. What you can't do, VAT is a transactional tax. What you can't do is say, in this hypothetical example, because your resuppliers of the flights or the hotel room are in the scheme, therefore all the other supplies that you as a trader make are in the scheme. It simply doesn't work like that. In VAT law, each transaction has to earn its own treatment. I can be a supplier making reduced rate supplies for part of my business, standard rated supplies for others, scheme supplies for some others. There's no, it would be a clear error to say, well, here's a trader and some part of their supplies are in, therefore we can extrapolate and say they're all in. Perhaps if I can explain it this way, we say the tribunals, and my learned friend make a sort of ripple mistake, if I can explain it that way. You have the core supply A, the travel agent sector. And you have supply B, and you ask the question, are they identical or similar? And if you find that they are, you put B in with A, give it the like treatment. Then my learned friend says, but what if the address is near to an airport? Now we have supply C that's like supply B. And then the ripple effect goes on. Identify supply D that's similar to supply C. That's not how it works. One doesn't establish similarity with another supply that came in because it had similarity. In every case, the question is, A, what is the core supply that's in the scheme? And it's the supplies of the travel agent sector. One can't have a supply coming in unless it's sufficiently similar to that supply. As I say, we invite the court, on the basis of the findings of the first tier tribunal and applying the right test, to allow our appeal. I was going to turn up the legislation. I've heard what my lord said about being familiar with it. Can I just run through the key points there?
Yep.
Yeah, can I ask one point of
course.
clarification? Are both parties proceeding on the basis that there is no material difference between the European and UK legislation?
We are, and if there were, it's been agreed from day one, the domestic legislation should be interpreted as far as possible in conformity with the directive.
Okay, so the conformity principle is accepted as applied, and I think you're both relying primarily on European case.
So I can skip, as it were, the domestic legislation if your lordships and ladyship have looked at it. I'm happy to do that. Okay, so can I go to the
Given
direct?
that common ground, one could just focus on the European legislation and the European case law.
That's mostly what I will do. If there is anything that my learned friend says about that, I can come back to the domestic legislation. So if your lordships want to, and ladyship want to have it open in front of you, it's page 6 of the authorities bundle. I'm not going to read it out, but just keep an eye on it as I run through my submissions.
Special scheme for travel agents.
Precisely, my first point, my lord. Special scheme for travel agents. Not special scheme for passenger transport resupplies or anything like that. Article 306, I'm simply paraphrasing now, that's the primary article that sets out what supplies are covered by the scheme. It's to be applied to supplies of travel facilities by travel agents, and that includes tour operators in point 2. It applies to travel agents or tour operators when they make the supplies using supplies provided by other taxable persons. That is when they buy in and sell on. For short, we've been referring to those as resupplies. It doesn't apply to travel agents acting as intermediaries, agents. Such traders aren't supplying travel facilities, they're supplying their agency services. There's no definition of travel agent or tour operator, and it's to be given its ordinary meaning. And that's how it's used by the CJEU. Just to note, no case sets out any distinction between travel agent and tour operator, and nothing turns on that for our purposes. Then what Articles 307 and to 310 then do is set out the effects of a supply coming into the scheme and its significant modifications to the normal VAT position. And if I could just explain what I mean by the normal VAT position, I'll take this quite quickly. There are generally 4 issues that arise in VAT law. The consideration question, how much was the supplier paid by his customer for the supply, and that typically is the amount on which VAT is charged. The second key question is the place of supply. Where is the place of supply for this particular supply? Because that tells us which member state is entitled to the VAT on the supply. And under the normal rules, passenger transport supplies have a place of supply where the transport takes place according to distance. As I've said, for hotel rooms, it's whether, for accommodation, it's where the accommodation is located. The third question in VAT law typically is the VAT rate. Does the supply attract the standard 20% rate, or does it come within a list of exemptions or reduced rate supplies or zero rate supplies? And finally, under normal VAT rules, you have the input tax question. What VAT was the supplier, what VAT did the supplier incur in order to make its own supplies? What VAT was it charged, and that's deducted. And importantly, the special scheme modifies the normal position in all these respects. So again, paraphrasing. Article 307, the place of supply of services within 306 is where the travel agent is established. And that's the member state that will get the VAT under the scheme. Under Article 8, this is the most stark modification on the facts of this case. As I say, under the normal VAT rules, if somebody supplies a holiday for £300, then they'll account for VAT on the £300. And if they supply a minicab ride for £36, they'll account for VAT on £6. Under the scheme, VAT is charged instead on the margin. So the difference between the amount paid by the travel agent in buying in the flight or the hotel room and the amount it charges in selling that flight or hotel room on. And the corollary of that modification is Article 310, that the travel agent or tour operator cannot make an input tax deduction in relation to inputs that go into making the supplies. Now, in this case, it's common ground that the effect of the modification is significant, hence the large sums involved, and that's because Bolt is buying in from a taxable person, the driver, but not one that is, in the vast majority of cases, above the VAT threshold. So Bolt, in the vast majority of cases, would have, under the normal rules, no input tax deduction to make in any event, because it wouldn't be charged VAT by its supplier driver. So as I say, if Bolt is under the normal rules, it charges £36 for a cab ride. it would account for VAT of £6. If Bolt is in the scheme, taking into account the margin, i.e. the difference between what it charges and what it pays its driver, it would account for VAT of only £2.66. My learned friend has accepted that has always accepted that that's an accurate example. Article 309 is about supplies made outside the EU. We don't need to look at it in any detail. I might come back to it for ground 2. Before leaving the special scheme, I made a submission in outline that the high-level approach, one of the reasons it's wrong, is because it erases travel agents and tour operators from the scheme. And we can see, looking at the scheme, how it does that. It assumes it's simply a special scheme for traders. It then says that member states shall apply a special VAT scheme in accordance with this chapter to transactions carried out by traders who deal with customers in their own name and use supplies of goods or services provided by the taxable persons in the provision of travel facilities. Then, para 2, for the purposes of this chapter, this is where it really makes no sense, traders shall be regarded as traders. There's one further modification of the normal VAT position that's not clear on the face of the scheme, but it's been established by the case law. Where a supply would, under the normal rules, attract an exemption, a reduced rate, or a 0 rate, it loses that if it's a scheme supply. So
We
that,
don't need to get into that kind of detail, do we?
well, we say it shows, if, I perhaps won't take you, Tim, but I'll just make the point I'm making. There are these lists of reduced rates or exempt supplies or 0 rates. And in those lists, you see passenger transport or holiday accommodation and so on. And what I'm getting at is that the scheme separates those out from the special scheme, and there are benefits to qualifying as passenger transport, which are lost on entry into the scheme. And the reason I wanted to stress that is because I'm facing, as it were, an opponent who uses the argument from simplicity and says, well, let it all in.
Can you just, I know you're not taking us to, but can you just give us the reference that you have in mind
Yeah,
in relation to passenger transport in particular?
Yes,
That would be
you have the,
European legislation if there is such a thing.
yeah,
Not now, but you can come back to it.
yeah, just so that I'm not fiddling around, can I come back to it after lunch?
Yes,
I've got,
of
because
course.
it's partly in the clips I handed to you.
Yes, thank you.
Yeah, so again, without going to it, the UK was entitled to retain a 0 rate on entry into the EU, and it retained the 0 rate of applying to passenger transport of more than 9 passengers. And the 0 rate is the golden ticket, because for exemptions, the supplier doesn't charge VAT, but it can't claim input tax deductions. For 0 rates, it gets the best of both worlds. And I make the point that if minicab operators typically had held more than 9 passengers, no doubt my learned friend will be standing where I am saying, we're not travel agents, look at the different features that we have. So I'm skipping the domestic implementation, but I'm happy to come back to it if there are any issues. Turning then to the key case law. And when we go to it, it's helpful to bear in mind the competing tests here. As I say, according to my learned friend in the tribunals, if a trader makes a resupply of passenger transport, that's sufficient for inclusion in the scheme. That's the high-level approach. And we say the test is that the supply has to be identical or sufficiently comparable, in particular to the supplies of travel agents and tour operators. And there's a series of propositions in our skeleton argument, but I'm going to group them under three headings, if I may, that we say support our test. To introduce them, heading 1 is that the scheme is indeed special, contains important modifications from the normal VAT rules, and that the legislature evidently selected specifically the travel agent sector for that special treatment. And that's an important point because, as I say, the high-level approach effectively erases the concept of travel agent and tour operator from the scheme. Heading 2, as with all derogations and exceptions from the normal rules, the scheme is not to be interpreted, is to be interpreted only to the extent necessary to meet its objectives, and is not to have an expansive interpretation. I stress that because my learned friend insists that it be given a broad interpretation. Heading 3 will cover the 3 key cases that deal with our very question. So turning to heading 1, the selection by the legislature of the travel agent sector for special treatment. We know the scheme expressly identifies the travel agent sector, and I've set out already how it provides special treatment, which changes the normal VAT position in fundamental ways. Now, the scheme doesn't give the travel agent sector as a mere example. It was the sector deliberately chosen, and we also know the reason why it was chosen. We turn up Van Ginkel, Authorities Bundle, page 102. Van Ginkel supplied motoring holidays. It was a Dutch travel agent supplying motoring holidays in the Netherlands. And for those supplies, it brought in the relevant holiday bungalows and supplied them on, but without any sort of transport. And there was a question, well, does it need to have some transport, because there are references to travel facilities and so on. What I want to stress, and what's repeated in almost, if not every other case, is what's said at paras 11 to 14. To begin with, it's appropriate to specify content and aims of Article 26. That's simply the predecessor to our scheme in the same terms. Article 26 of the directive defines a special scheme of VAT applicable to travel agents and tour operators. The services provided by these undertakings most frequently consist of multiple services, particularly as regards transport and accommodation, either within or outside of the member state in which the undertaking has established its business. This is important. The application of the normal rules of taxation, taxable amount, deduction of input tax, would, by reason of the multiplicity of services and the places in which they're provided, entail practical difficulties for those undertakings of such a nature to obstruct their operations. And in order to adapt the normal rules to the specific nature of operations, of such operations, the special scheme for travel agents is adopted. And on the question, well, what about Van Ginkel, who supplied only accommodation, a single service, and indeed domestically, although the court doesn't here discuss the fact that it's a domestic supply, the court's answer is 22 to 23. The application of the special scheme of VAT envisaged by Article 26, the transport of the traveller to and from his accommodation should be arranged by the travel agent. 23. Such a requirement would run counter to the aims of the directive, As has already been indicated, those provisions adapt the rules governing VAT to the specific nature of the operations of travel agents to meet the needs of travellers, of customers. Such agents offer widely differing types of holidays and journeys, allowing the traveller to combine as he wishes transport, accommodation and any other services those undertakings may provide. The exclusion from the field of special scheme provided for by a travel agent on the ground that they cover only the accommodation and not the transport of the traveller would lead to a complicated tax system in which VAT rules applicable would depend upon the constituent of the service offered to each traveller. So, as the CJU explains there, the aims of the scheme are tied entirely to the fact that the travel agent sector most frequently faces the difficulty of having to register in multiple jurisdictions. So if I'm a travel agent supplying coach transport from my home state, France, to Germany to Austria and a hotel room in Austria, under the normal VAT rules, I would have to register in my home state, I may be repeating the wrong countries, but Germany, Austria, and so on, account for VAT there and claim input tax deductions there. And that's a considerable headache, of course, and as the CJU says, sufficient to obstruct their operations. And that's why they're given a special scheme. Because the problem is faced by that sector most frequently, and it's a serious problem. Why then does Van Ginkel say that Van Ginkel can have the scheme? It was making just the supply of accommodation, and as it happens in its home state. But the CJU has explained why. It would be contrary to the objectives of the scheme if you asked the travel agent to account under the scheme for supplies that were multiple services in multiple places, and then have to go back to the normal rules if actually one of its supplies happened to be a single supply, a single domestic supply. And of course, the same travel agent might make a single supply in France to one customer, but be making a single supply in Austria to another customer. So the fact that it's a single supply single service doesn't necessarily get rid of the jurisdictional headache.
Does this run counter to your point about doing it on a transaction basis? Might it be said that you're treating two what are distinct transactions, but you're treating them as the same, even though they're not the same?
Not at all. What I'm getting at is that the travel agent sector wasn't identified accidentally. It was identified because as a sector it most frequently has this problem. And of course, when you have a rule, it can identify, and you need to apply it, you say travel agent sector, of course it can therefore catch within it travel agents who don't need it. And it might keep out traders who do need it. You have the same headache. But you pick the travel agent sector, as Van Ginkel explains, because that way you target those who most need it. Now, VAT is on a transactional basis, so but nothing I've said so far contradicts that. Each supply on our test to get into the scheme would have to show that it's identical or similar to travel agent supplies on the ordinary meaning. I don't yet see the conflict, but I will have to think about it and come back if I haven't answered. And as I say, it was a domestic case in Van Ginkel, but it didn't discuss that aspect. But we'll see it made clear in the Madgen and Baldwin case that not having an overseas element isn't a problem. And that's presumably for the same reason given in Van Ginkel about it's not a problem if there aren't multiple services. We're trying to uncomplicate the lives of travel agents. We're not going to ask them to look at the constituent element of each of their supplies and then account under two different systems. And a related reason, of course, is presumably the principle of general fiscal, so I'm going to quickly, fiscal neutrality again, because you can't have a French tour operator who makes a supply in Austria be allowed to account under the scheme, but an Austrian supplier making the same hotel supply in Austria using the normal rules, because that might create a fiscal neutrality issue. Now, as I say, of course, not all travel agents face the difficulties the CJU describes. Not all need a special scheme. And nobody's suggesting that the special scheme applies only to supplies that involve multiple member states or more than one supply. But the reason travel agents get the special scheme is, as I keep saying, they're the traders who most frequently do need it, because they most frequently do make these multiple supplies in multiple places. Those are characteristic and typical of the sector, and the normal rules risk obstructing their operations. I don't emphasize these points to say, bulk loses because it's not making multiple supplies in multiple jurisdictions. Of course, that's clearly not a reason to, a basis on which I can say bulk can't come into the scheme. The reason I'm emphasizing the objective is to make good the point that it is indeed the travel agent sector that was singled out for special treatment. The reference to the special scheme for travel agents is not accidental or a mere example. Reasons have been given for why that sector was picked out. And not the wider passenger transport sector. And I think I've already given the example. If I'm a coach operator that owns my own fleet of coaches, doesn't buy anything in, I'd have the very same headache if I weren't supplying coach transport from France to Germany to Austria, but they don't get a special scheme. And the objective of the scheme, to aid the travel agent tour operator sector because they most frequently face problems under the normal VAT rules, is repeated in the case law. I'm going to give you the references and the dates of the cases for a reason I'll come on to in a second. Magid, Baldwin, 1998, page 136 of the authorities bundle at 18. IST, 2006, authorities bundle, page 172 at para 21. Minerva, the opera tickets case, 2011, page 229 at paras 16 to 17. Cossack, 2012, authorities bundle, page 237, paras 19 to 20. Commission in Spain, 2013, authorities bundle, page 263, paras 58 to 59. And most recently, Director Kračovic, 2023, page 384, paragraphs 20 to 21. And I stress the dates because my learned friend's position is that the objective of assisting travel agents, because they make multiple supplies in multiple places, no longer has any relevance. Because my learned friend would say, we know from the case law that the scheme can apply to single services that are merely domestic. And we say that misses my point entirely. Of course, the scheme can apply to single domestic supplies. That's always been common ground. The important point I make is that the travel agent sector was selected as the sector which would get the special scheme, because that was the way to cover the traders who most frequently face the problem and need the scheme. It's not a scheme, however, for any trader who needs it. It's not a scheme for travel agents who need it. It's a scheme for travel agents because they most frequently and typically need it. My learned friend can't meet that key point by pointing to the fact that a single domestic supply by a tour operator can also come within the scheme. So we say it's clear from the express wording of the scheme and the CJU's explanation of the objectives of the scheme, its purpose, that it really is a scheme for travel agents. They're at the heart of the scheme, and the error my learned friend and the tribunals make in adopting the high-level approach is to erase that concept from the scheme entirely. So how to identify the supplies in the scheme? How do we interpret the terms travel agent and tour operator? Those aren't defined in the directive, and we'll see that the cases use them on their ordinary meaning. And when they're not defined, the right test is to look at the ordinary meaning, taking into account the context in which they appear and the purpose of the rules of which they are a part. If I can give your lordships references for those 2 points. The first is Authorities Bundle, page 153, the Meyerhofer case, paragraph 27. And in this court, Romford, on page 466, paragraph 99. So the context of the special scheme tells us we're dealing with travel agents and tour operators, obviously, who supply travel facilities themselves, not travel agents who are acting as agents at all, using supplies of others, buying in and selling on. On the ordinary meaning of travel agent and tour operator, without giving a definition, we have some common ground because Bolt accepts and has always accepted it's not a tour operator or travel agent on the ordinary meaning of that term.
I take it from the way you put it a number of times, you're not going to give us what you say travel agent means.
It's easier to say that it's not minicab operators. Of course, and the FTT recognises this, of course they typically make transport using planes, trains, coaches, but it's easier to say what they don't do, which is certainly not private car transfers from anywhere to anywhere, i.e. they're not a sector that says, contact us and we'll take you. So imagine millions of maps of routes zooming around London. Those are the minicab rides. Travel agent or a tour operator does not say, contact us and we'll take you wherever you want to go along these routes.
Okay.
At best, it says, if you're coming to the airport and you've bought a flight with us, we'll arrange a transfer. So it's not private car transport from wherever to wherever, door to door, to any particular point B the customer wants, on demand. Sorry, I'm trying to skip so that I can keep in the time suggested.
You're doing pretty well, if I may say so, Ms.
As I say, we have separate terms for those who do what Bolt does, and it's minicab operator.
Yep.
If I could turn to heading 2, that the scheme as a derogation has to be interpreted strictly and certainly not in an expansive way. And I stress that because my learned friend supports a broad interpretation and claims that...
Cutting to the chase on that, I haven't seen reference to strict interpretation in the way that it's used when looking at VAT exemptions. But do you say it comes to much the same thing, or
much the same thing.
what the courts have said?
I'll answer that in two
Yes.
ways. First, much the same thing, because although apart from an Advocate General, we don't see reference to the words strict interpretation. What we see repeatedly is only to the extent necessary to meet its objectives.
Yeah.
We're not here arguing, all right, at least I'm not arguing that this is a fine difference. What I'm saying is that applying it to bolt is an expansive approach. And an expansive approach certainly is not only to the extent necessary to meet its objectives.
So this is Majid and
But-
Paul win paragraph 34, and that mantra has been repeated subsequently.
Yes, and just to answer my Lady Falk's question directly, there is another special scheme case in the bundle. It's Commission in Austria, and if I could just read from page 222 how it's put there. It's looking at Article 24, which is another special scheme, and it says, firstly, it should be recalled that Article 24 gives Member States an option of applying a special scheme to small undertakings, which constitutes an exception to the normal rules of the directive. Like the other special schemes provided for in Articles 25 and 26, that's our scheme, the special scheme for travel agents, by its old name. Scheme under Article 24 must be applied only to the extent necessary to meet its objectives. Moreover, it is settled law that any exception to or derogation from a general rule is to be interpreted strictly. So I don't say strict and ever to say go against the purpose of the objectives of the scheme.
Okay, so that is a reference to strict, for what it's worth.
And there's a reference to strict in the Advocate General's opinion in, I think, Upper Tribunal, which I'll give you, Your Ladyship, the reference for. I use strict in a way as a shorthand for, as an exception, a derogation, it mustn't be interpreted
Beyond what's needed.
precisely. And it's just easier if I could
Okay,
I say
thank
strict
you.
with that caveat
That's
in mind.
helpful, thank you.
Certainly not expansive is another way of putting the same point.
As I understand it, you're not urging a distinction between interpreting strictly in this context and applying only to the extent necessary to achieve its objective.
No, as I say, I use it as a shorthand.
Yes. Thank you.
If I may continue to do that, but subject to that point that I mean it in that way. But bearing in mind the case I just took your lordship to, that the CJU itself says of these derogations that it's both strict and only to the extent necessary to meet the objectives.
Yeah, and the paragraph cited from Majid and Baldwin is paragraph 34, which is indeed about our exception.
Precisely, my lord. So to give your lordships and ladyship an example of the strictness, or again, from now on I'm using it in the way we've just discussed. Example of the strictness of the correct interpretation of the scheme. Perhaps I can do that without turning it up in terms of speed. It's the Kozak case. It's for your note, it's Authorities Bundle, page 237. And Miss Kozak was a travel agent who supplied inclusive packages of accommodation, meals and coach transport. Kozak bought in the accommodation and meals, but used her own fleet of coaches in supplying the package to her customers. And the CJU decided that Ms. Kozak had to use the special scheme for the bought-in accommodation and meals aspect of the package, but had to use the normal rules for the in-house coach transport. So despite the rule being to uncomplicate the lives of travel agents, its strict application meant that even when supplying these together, an in-house element of the package has to be extracted. And we see at paragraph 25, the CJU noting that the coach transport was an essential element of the package, and that didn't matter. What the CJU is doing there is saying it doesn't matter that it's an essential element of the package. That would normally matter under the normal rules, because under the normal rules, a package, if it's a single composite supply, all the elements are treated in the same way. But one doesn't do that for the special scheme because of its strict interpretation. You don't bring in the in-house coach transport into the scheme. It has to be split off. Miss Kozak was happy, incidentally, because she enjoyed a reduced rate under the list, the references of which I'll give after lunch in a succinct form. She didn't want to be in the scheme because her coach services would have the reduced rate. My travel is probably a case I need not to go to because it's a little bit complex for the short point I wish to make. If I could outline it in this way, my travel was in a very complicated position. It was a travel agent who bought in flights and on-supplied them, i.e. scheme supplies, but it was also supplying flights using its own airline, i.e. in-house non-scheme supplies, and it was selling both those types of flights in-house and bought-in, with bought-in accommodation in packages. And of course, my travel had to extract from these packages the in-house elements in accounting under the scheme. And there was an argument, and this is a detail I don't need to go into, but there was an argument about how it could do that. Normally it's the market value, but it didn't know the market value. In certain cases, could it then use the cost value and so on? And it was complaining about all this complexity, to which the CJU said, the scheme is not a simplifying accounting system, deal with it. And that, we say, is another instance of the strictness of the rules that I support.
Can you give us a paragraph, please?
Yes, sorry.
Is that highlighted?
Yeah, it's really paragraph 39. It's just on page 205, but in order to get to it, it takes some working through the complexities, but that's really the key point. And Scarpa Travel was, again, to avoid the detail, was an issue about the time of supply. Scarpa was a travel agent, and it was saying, well, how can I work out my margin? I've sold the holiday, but I haven't worked out all my costs yet. How can I use the normal time of supply rules? I should use the scheme for those too. And the CJU says, another instance of strict interpretation, no, you only, and the scheme doesn't say use the a different time of supply rule, so use the normal one. It's paragraphs 24, 27, and 29 to 30. And in answer to my lady's earlier question, I'll just show your lordships and ladyships quickly what the Advocate General said about strict interpretation. It's page 319. I won't read it all out, but it's just sticking to the sort of the key parts. On the purposive level, it ought to be recalled that the Articles 306 to 308, rather the entire chapter of the VAT Directive entitled Special Schemes, for the respective sectoral activity, it could thus be suggested that the EU legislature wished to establish a separate scheme, potentially derogating not only from those elements expressly provided for, but from all the elements. 40, I do understand the broader logic of that argument. It would appear nonetheless that such an approach is at odds with the established case law, which insists on a strict and narrow interpretation of any departure from the general VAT regime, both generally as well as specifically with regards to special schemes for travel agencies. Dropping to 42, as regards the special scheme for travel agencies, the court has repeatedly called as an exception to the normal rules, must be applied only to the extent necessary to meet its objectives.
Thank you.
Sorry, there's one other case on this I should show your lordships and ladyship. It's Commission in Spain, and I just need to show you it quickly for two reasons. It's on page 244.
So sorry, I hadn't picked up, forgive me. Scarpa, what you were showing us in Scarpa was the Advocate General, not the judgment, wasn't it?
I thought I gave the paragraph references
Yes.
for the judgment, but
That's
yes,
fine.
oh no, certainly, yes.
But you did give paragraph references to the judgment as well,
But it doesn't use-
not for the strict.
Not for the strict one.
Precisely. Right. Other than the Austria case that talks about the special schemes generally, I couldn't see specific use of the term strict interpretation. But of course, that's the CJU saying strict interpretation and referring expressly to Article 26, i.e. the special scheme for travel agents. So it's not something I've made up as it were.
Thank you. So we're on tab 20, it says two European Commissions.
This is Commission in Spain. No, the tab 20 is the opinion of the Advocate General. I don't need to go to that, it's tab 21.
21, thank you.
There are 2 points in this case. The first is the court will recall that it supplies to travellers. And there was a question, well, what if you have travel agents supplying to travel agent, supplying to the end user? Does travel agent to travel agent come within the scheme? Because obviously travel agent 2 isn't the end user traveller. And there's a debate about whether some countries say traveller and others say customer and so on. And the CJU decides in this case that traveller should be understood to mean customer, so that a travel agent supplying to a travel agent to on supply still comes within the scheme. And if I could just whiz through the relevant paragraphs. 273, at paragraph 58, just scanning it, one will see they make multiple supplies in multiple places, and normal rules would be such as to obstruct their operations and so on. The objective is to simplify the lives of travel agents. And then it says at 60, the customer-based approach is the most conducive to achieving those two objectives by permitting travel agents to benefit from simplified rules regardless of the type of customer to whom they provide their services. The fact that when the special scheme for travel agents was adopted in 77, the majority of those agents sold their services directly to the final consumer doesn't mean the legislature intended to limit the special scheme to sales of that kind and exclude sales to other operators. Where an operator organises a package travel service and sells it to a travel agent who then sells it to a final consumer, it's the first operator who takes on the task of combining several services purchased from various third parties. In the light of the objective of the special scheme for travel agents, that operator must be able to benefit from the simplified rules. And then skipping to the other objections raised by the Commission to the customer-based approach cannot call the analysis into question. 65, the fact that the special scheme for travel agents is an exception to the normal rules, so that as such the exception must not be extended beyond what is necessary to achieve its objectives, does not however mean that the traveller-based approach must be adopted if it compromises the effectiveness of the scheme. And then at 66, summarising, it felt able to say traveller means customer, because otherwise the objectives of the scheme would be compromised, and it felt able to say that because the use of customer and traveller across member states varied. So it was given that room. Of course, my learned friend doesn't make any claim that if the minicab sector weren't included in the special scheme, that would compromise the aims of the special scheme at all. Perhaps, again, I can do it just by giving a reference. Authorities Bundle, page 371, is the Frenety-Kexito case. It's a case on exemptions, and it's considering the question whether nutritional monitoring service qualifies as hospital or medical care in closely related activities. And for your note, it sets out strict interpretation at paragraph 22, and then sets out the principle of fiscal neutrality, which we'll see mirrored in Madgett and Baldwin. Let me just check I've got hold of them.
Possibly.
32 to 33. It sets out at 32 on page 376 the principle of fiscal neutrality. My Lord Arnold asked me about earlier. Without reading it word for word, we can see the identical or similar wording that we see in Madgett and Baldwin. And then at 33, it says, don't extend the scope there of an exemption, but you have my submissions on any derogation not being an expansive one. And then before turning to the three key cases that are to do with the test here, I could show your lordships and ladyship briefly, and I'll take it quickly because my lady, you indicated you've seen it already, the Minerva case.
Yes.
In that case, the CJU made clear that where Minerva sold its flights and accommodation in a package with opera tickets, the opera tickets would be in the scheme. That doesn't contradict the Cossack case. Remember, Cossack had to extract its coach transport from the scheme.
Well, would you
because
rationalise that as the opera tickets clearly being ancillary in the Minerva case?
Ancillary.
Whereas the coach can hardly describe
Yeah, it doesn't discuss
the coach supplies as ancillary.
To be fair, the CJU doesn't get into whether it's ancillary or not, the coach transport. It's simply, the reason it's excluded is because it's in-house. That's the reason given.
Yes, of course.
But the point I'm making is that
Yes.
we shouldn't make the mistake of thinking that because of that, the ancillary packaging wouldn't normally bring in an ancillary supply as long as it's not in-house.
Yes.
And that's what happened with the opera tickets. They were brought in, they were packaged, therefore they could be in the scheme, but opera ticket sales alone can't be in the scheme. And obviously they can't be because they're not supply of travel facilities, so I accept that. But we're saying for any airport transfers that potentially come into the scheme, well, they would come in anyway because of the typical packaging with the flight or hotel. And so again, to take it, I hope not too quickly, just want to show your ladyship and lordships point I rely on by analogy. It's page 228. again, sorry, starting at 229, I'm not going to read these paragraphs, but just to highlight paragraph 16, we see the setting out of it's an exception to the general rules, must be applied only to the extent necessary. Then we see the objective, to adapt the applicable rules to the specific nature of the activity of travel agents. 18, we see a repetition of, because in that sector, traders most frequently suffer the problem by reason of the multiplicity of services and the places where they are provided, such as to obstruct their operations if they had to use the normal rules. Then we see at 21, the opera tickets aren't going to be in because they don't even relate to a journey. It would have to be travel facilities, accommodation or transport. And then it's 24 I rely on. It should also be observed that the application of that special scheme to an activity such as that an issue in the main proceedings, where the travel agent merely sells tickets for performances without the provision of a travel service, would distort competition in view of the fact that a given activity would be taxed differently according to whether or not the trader selling those tickets is a travel agent. What I'm trying to take from that is that, assume, if you like, a sort of Venn diagram. You have the travel agent tour operator circle, and you have the minicab operator circle, relying just on ordinary meanings. And then, according to my learned friend, there's an overlap. There's a little segment where the two overlap. And in there you have, for example, the airport transfers for 2.3% of supplies. And the point I'm making is, of course, when you're in that situation, you have to look at, in this overlap segment, is it identical or sufficiently similar to the travel agent sector to go into the scheme? But have an eye on the fact that you have the other circle. Or is it more closer, in fact, more similar to the minicab sector, in which case you take it out of the scheme? You see something of that in paragraph 24, where the CJU says, well, we can't let opera tickets in because there's this other sector dealing with opera tickets, and that would distort competitions the other way. And so, obviously, it depends on whether you agree with me that there is this Venn diagram, but I say it's not a one-way street. When dealing with fiscal neutrality, one always has to have in mind, well, similarities with one contender group, having in mind the similarities with another contender group. And that's why I say the 2.3% of airport rides aren't a problem, because when seen in that way, although they happen to have a destination that's an airport, in all other respects, unpackaged, private, door-to-door, on-demand service, there are far more similarities with the minicab circle.
Well, you might say the fact that the destination is an airport is happenstance. It could be a pub next door.
It could have been near to the airport. It could have been, this is the point when I say, both slogans are wherever, whenever. Ride in seconds, request in seconds, ride in minutes. The routes, all the potential A's to B's that any customer could choose are anywhere. So that's the London map of all the lines of routes going across. There's no claim that travel agents or tour operators on their ordinary meaning do anything like that. And I think the court has my packaging point that typically and this is what the FTT also thought, typically they're packaged and scheduled. It would be very odd if you were booked your flight with the travel agent and they were going to offer you as part of the package, or you buy as part of the package a transfer that they say no scheduled time. I'll come on to this, but just so that it's not lost. On-demand means, of course you book a cab, but you can't specify a time at all. You can't say, it's now 11:56, you can't say pick me up at 12, you can't say pick me up at 3, you can't say pick me up at 10. You simply can't give a time. So that's why I keep saying it's where the customer happens to be standing. Because if you request that cab and you can't give a time, then you can't say, it has to be from where you're standing, unless you get lucky and you can run to the house next door, whatever it is. So it's from wherever the customer's standing to wherever they want to go, and you can't schedule a time. And in my submission, airport transfers from travel agents don't work that way. You can't risk the unreliability of an unscheduled ride. Of course, Bolt might come in 15 minutes, but it might not come. And that's not comparable, therefore, even in that potential small overlap section in my imaginary Venn diagram. And that brings us to the three key cases that deal with the test dispute we're having that's at the heart of this appeal. I can start with the first case, Madgett and Baldwin. Page 120. No doubt this is one of the cases that the court has read, so I'll just take it very quickly. The facts were they were hoteliers. 90% of their customers bought a package consisting of in-house hotel accommodation, i.e. made by the hoteliers, Madgett and Baldwin, but also return passenger transport by coach from the north of England down to Devon, and an excursion by coach during their stay with Madgett. And that coach transport from the north of England down to Devon and the coach excursion were brought in and supplied, by Madgett and Baldwin. Now again, Madgett and Baldwin didn't want to come within the scheme. But HMRC argued that you have to be in the scheme because what you're doing is the same as what travel agents do. And the CJU decided that the transport and the tour, the coach tour, were in the scheme. My lords, I'm in your hands. Obviously, paragraph 18 to 27 are key paragraphs. And the dispute between us is whether it supports my test or my learned friends. So it's important. Would you like me to read it out? Are you sufficiently familiar?
I think we've all read it, so
Okay,
you
well, then
need
I'll
to make
pick
your
out-
point. You need to make your
Yeah,
points.
thank you. Sorry, if you could just bear with me, I'm trying to cut back. So, paraphrasing and stressing the points. So paragraph 18, we see the aim of the special scheme. Paragraph 19, the principal reason for the scheme, the cross-border headache that travel agents and tour operators face because of they most frequently make these types of multiple services supplies. And then there's a setting out of the reasons why those who are not travel agents and tour operators in the normal meaning, but who affect identical transactions in the context of another activity, such as that of hotelier, come within the scheme. And the reasons given relates to the need to treat like cases alike and avoid distortions of competition. So that's why we say paragraphs 21 to 22 of Madgett in particular make clear that the test is, as I say it is, and we'll see that also in other cases. But what the FTT and Upper Tribunal did,
Sorry, they make clear what? I didn't quite catch it.
sorry, they make clear that the test is, difficulty with this. The underlying reasons for the special scheme, paragraph 20, are equally valid where the trader is not a travel agent or tour operator within the normal meaning of the terms.
Yes,
affects
there's a
identical.
reference to identical transactions.
Yes.
I see somewhere, not this case, I think, a reference.
Are
to
they at least comparable?
Yes,
Yes, now I'll come on to that.
okay, but
And
for
I
the
accept.
purposes of this case, they're saying this is identical.
Yes, and I accept, of course, that the later case says, or at least comparable. That's why our test is identical or sufficiently comparable. And the reasons given for applying the scheme to, in Majid's words, identical supplies is that it would prejudice the aim of that provision, create distortions of competition, and jeopardise the uniform application of the 6th directive.
So it would prejudice what exactly?
Paragraph 22, sorry.
You said it would prejudice something. What would it prejudice?
Prejudice
I'm
the
very
aim.
simplistically looking for the word prejudice because I thought you were reading out.
22.
Yeah.
Prejudice the aim.
Oh, I see. I'm sorry. Thank you. Yes. Very good.
Now, what the FTT did and what the Upper Tribunal did was focus entirely on paragraph 23. And we say went wrong, each of them regarding different parts of 23, so wrong in different ways. Again, I don't know how carefully I should take it in terms of time, but I'll make the point now and perhaps highlight it again when we come to the decisions. What the FTT said at paragraph 106 of its decision is it's sufficient that it's passenger transport resupplies because in Majid, in paragraph 23, we see in that third line reference to generally associated with that kind of activity.
So your key point is that you focus on the earlier paragraphs and the reference to sort of formal classification and what you say the court is getting at
Well,
in terms of creating, for example, creating distortion of competition.
Yes, but also, so the one point the Upper Tribunal agreed with me on, that the FTT's defence of the high-level approach by relying on the wording generally associated was wrong. See last 5 lines of paragraph 60 of the Upper Tribunal decision. Because what paragraph 23 is saying is the scheme applies to traders who organise travel or tour packages in their own name and entrust other taxable persons with the supply of services generally associated with that kind of activity. What they're getting at there is a travel agent's supplier is the airline. But that airline, as well as being the travel agent's supplier, is also the party to whom the travel agent entrusts performance of the supply and services generally associated with the supply. So when I buy my flight from the travel agent, who's bought it from the airline, what's happening is it's actually the airline who's going to board me onto the plane and take me through the safety procedures and serve me my drinks and peanuts. That's the generally associated activities that the court is getting at there. So the first reason given by the first tier tribunal at paragraph.
But they're actually getting at the airline supply there, not just the drinks and the peanuts, aren't they? Maybe it doesn't matter, but I'm not sure I follow that.
So if
what the travel agent is doing is entrusting the airline with all of it.
yes, but one can't take from that the high level approach as the FTT does and say Oh, well, there's a reference to generally associated, so it's anything generally associated with travel agents that's in the scheme. Or sorry, with travel, I should say, that's in the scheme. And as I say, the Upper Tribunal agreed with me on that point, see paragraph 60, and my learned friend hasn't contested otherwise. But what the Upper Tribunal then went on to do is say, actually, paragraph 23 is important for a different reason, because we see there the general reference to traders who organise travel or tour packages. And it's the use of trader to organise travel, which just means they're resupplying, of course, that gives the Upper Tribunal the heart of its support for the high-level approach. And we'll come to it, I don't want to misquote it, but it says of the earlier paragraphs in the context, well, that's just to do with a particular supplies an issue in that case. And we say that's certainly wrong. It's clear from the Madgen and Baldwin decision and how it's described in the later cases I'll come on to, that at the heart of the test is, are these supplies identical or sufficiently comparable to the supplies of travel agents? And that's not an accident. Why are we even thinking of putting these supplies in the scheme? Because it's a scheme for travel agents, but it'd be contrary to fiscal neutrality to keep out supplies that are identical, albeit made by somebody else. So what's Madgen and Baldwin doing? They're hoteliers sitting in Devon, looking after their guests with their in-house supply of hotel rooms. But when they decide to buy in and resell to their customers as part of their package, the coach transport from the north of England down to Devon and the coach excursion, they're doing what travel agents do, identical supplies, and uniform application of the PVD says that they must be in.
Just looking at 23, and you were making a point about airlines.
Yeah.
Just looking at the words of 23, it says, it must therefore be held, so on and so on. Directive applies to traders who organise travel or tour packages in their own name. So that's a deliberate use of language which doesn't say travel agent. And they're deliberately not saying the words travel agent in that bit, because they then go on and then say and entrust, and then ... even if they are not formally speaking travel agents. And the they in that sentence, even if they are not formally speaking travel agents, refers back to the traders.
That's the Upper Tribunal's point. My answer to it
But
is
wait a minute, do you agree
Sorry.
that that's right as a matter of English?
that they are using the term trader there and not travel agent specifically, yes.
The they, the people who are, they are not formally travel agents, what it's referring to is not the taxable persons with the supply of services, it's the traders who organise travel. The point is there are two different people referred to in 23, and one of them, the bit at the end says even if they're not formally travel agents. And I've read that
Yes.
myself as referring to the traders, not the taxable persons.
Yes.
Do you agree?
Yes,
I
I agree.
mean, my reading is that the reference to formally speaking there links back to the reference to formal classification of the trader in 21.
Right.
What they're saying is, as I understand it, you're not in or out of this scheme depending on your label.
Yes, but it's not, I accept they say formal classification, but
Yes.
they also say the ordinary meaning. So
Where do they, oh, the normal meaning, they use that in
the
21.
normal meaning, and we see that
Yes.
picked up in the other
Yeah.
cases too. And we say, looking at the paragraphs as a whole and in context, Madgen and Baldwin is making the unsurprising point that the objectives are to catch the travel agency sector. Fiscal neutrality requires that if another trader, a hotelier for example, is making identical supplies, although it's a hotelier, it's not a travel agent, but it's making identical supplies, it's stepping out of its hotelier sector, if you like, and stepping into the travel agent sector when it buys in and sells this coach transport and the coach tour, then it must be in the scheme also. And that's where I get my test from. And of course, I note that at 23 it uses the term trader and not travel agent, but in context, my submission to say that Madgen and Baldwin supports the position that any trader providing travel facilities, buying in and reselling, is in the scheme,
yes.
is to erase the idea of travel agent from the scheme altogether.
Yes, I mean, the first reference to trader in this section is paragraph 20. Isn't it?
Yeah.
Which loops back to your point about what's the test. The test is here, identity, subsequently extended to comparable.
Yes.
So the point is 20, you say 23 is not the test. The test is in 20, identical. And I understand there's then it's comparable data.
Yes. And it would be surprising if the test, moreover, it would be surprising if the test were 23, because of all the points I've already made, and I apologise if I'm belabouring the point, but it seems to me important at the heart of all this. It's a scheme for travel agents, explained repeatedly by the CJU, because they typically, that sector in particular, most frequently faces the headache the scheme is trying to fix.
I think we've got that point.
Yeah, sorry, but well,
I've made it a number of times now.
I do apologise, but I'm here having lost twice, so because it seemed to us those points were missed. So I apologies if I'm overemphasising them. And then at 24 to 27, what the court goes on to do is say the coach transport in that case couldn't be seen as ancillary to the package, as in the package being the hotel, the in-house hotel room and the transport. Coach transport couldn't be seen as ancillary because it had a significant effect on the package price. But we also see, if I could just read out the wording, 24. As the Advocate General notes, traders such as hoteliers who provide services habitually associated with travel frequently make use of services brought in from third parties, which take up a small portion of the package price compared to the accommodation, and are among the tasks traditionally entrusted to such traders. Those brought-in services do not therefore constitute for customers an aim in themselves, but a means of better enjoying the principal service. And those ancillary services will be ancillary to the in-house and be kept out of the scheme. And 26 is the important one. Where, however, a hotelier habitually offers his customers, in addition to accommodation, services which go beyond the tasks traditionally entrusted to hoteliers, which cannot be carried out without a substantial effect on the price, such as travel to the hotel room from distant pickup points, such services are not equated with purely ancillary services. And of course, the court there is making the ancillary point, but we also see there another point I rely on, that what was happening was Madgen was stepping out of its sector into the travel agent sector, and of course I make the point that Bolt is not stepping out of its sector, it's doing precisely what minicab operators do, firmly within its sector. It's offering private car, on-demand cab rides to wherever the customer wants to go, door to door. Sorry, I'm skipping bits we've covered. I think I can, unless there are any questions, I can move away from Madgen to the second key case, which is IST. It's page 159. And just to introduce the case, IST was an education provider selling packaged overseas programmes to its students. And the case concerned particular packages to the USA. One was the high school package for 15 to 18-year-olds. And that included return flights to the USA from Germany with a guide, flight connections within Germany, return flight connections within the USA, and accommodation and meals with a host family. The college programme provided college accommodation and meals in a college, and the students organised their own flights. The question was whether these supplies I've just outlined are in the scheme. As I'll come on to, the court says they're not ancillary, and so they can't just be kept in with the in-house education service. They have to be in the scheme. But the key point is the test.
This is where we get at least comparable in paragraph 24.
Yes, but more importantly, as importantly, paragraphs 21 to 23 will see out the setting out of the magic test as I support. So 21, as regards the status of a trader covered by the scheme, should be noted that according to the case law, services provided by travel agents and tour operators most frequently consist of multiple services, in particular transport and accommodation, supplied either within or outside the territory of the member state, ... The application of the normal rules on place of taxation, ... would obstruct their operations. See Madgett and Baldwin. 22. The court has held in that regard that the underlying reasons of the special scheme for travel agents and tour operators are equally valid where the trader is not a travel agent or tour operator within the normal, note, not formal, but normal meaning of the terms, but affects identical transactions in the context of another activity, such as that of hotelier. To interpret the directive, Article 26, i.e. the scheme, as applying solely to traders who are travel agents within the normal meaning of these terms would mean identical services would come under different provisions depending on the formal classification of the trader. In the case of the main proceedings, it's not in dispute that he is not a travel agent or tour operator within the normal meaning of the terms. It is, however, necessary to decide whether it provides identical services to those of a travel agent or tour operator. So when the CJU came to look back at Madgett, we say it picked my articulation of the test. It's identical supplies to travel agents and tour operators, explained by the fact that it's the travel agent sector that's targeted, but one can't treat supplies that are identical differently for fiscal neutrality reasons. And then the answer, 24, it must be found that in the course of activities in relation to the high school and college programmes, is provide services which are identical or at least comparable to those of travel agent or tour operator, in that it offers services involving travel by plane of its customers and or their stay in the host state, in order to provide services generally associated with that type of activity. That's the peanuts and the room cleaning and the manned reception desk general activities. It uses the services of other taxable persons, namely here a local partner organisation and airlines. So in terms of passenger transport, we see the CJU saying not, well, it's a resupply of travel. It's a travel facility. We can erase from the scheme the concept of travel agent and tour operator and replace it with a trader supplying travel facilities. It says has to be identical, at least comparable to those of travel agents, and finds that identity in travel by plane.
So the identical services on the travel by plane
And the
and on the stay, and then the services generally associated are other things like the peanuts and the cleaning.
It's just making the point that they're buying in and reselling, and therefore the actual underlying performance is by the airline or the hotelier. as I say, the FTT read that wrongly, and the Upper Tribunal agreed with us that it read it wrongly. The reason I emphasise it is because when we come onto the FTT decision, what I aim to do is say 106, bad reason, 107, bad reason, and so on. And therefore, I'm just trying to identify that the support for the high-level approach is beginning to crumble, we say. Sorry, again, I think I've, to avoid repeating myself, if I could just take a second. So, summarising, the rest of the decision deals with whether the services could be said to be ancillary, in which case they wouldn't come into the scheme. And it deals with the objection from the German government, which said, actually, there's a Consumer Protection Packages Directive, and under the Packages Directive, a free stay abroad for up to a year with a host family would be, just make sure I don't get this wrong. Yeah, so it comes under the Packages Directive and couldn't be under the scheme. And at page 174, the CJU says, we're not interpreting the Packages Directive, we're interpreting the scheme. And this is where the Upper Tribunal tries to find support for its position, because again, we see some general wording used. It's true, reading from 34, it's true that that article does not include a definition of the concept of travel. However, in applying that article, there's no need to set out in advance the factors constituting travel. That provision applies provided that the trader in question is a trader for the purposes of the special scheme for travel agents, acts in its own name, and uses the operations of others. The relevant question is whether the supplies are not ancillary. Pausing there, the Upper Tribunal says, and here's the supportingist for the general position, because it's just saying it needs to be a trader making travel supplies. And we say you can't ignore the wording for the purposes of the special scheme, and the CJU setting out from 21 to 24 that being a trader for the purposes of the special scheme means being a travel agent on the normal meaning, or making identical supplies, or at least comparable. And 35 to 37 is trying to respond to Germany's objection and saying, well, nobody cares if the student is going there for educational purposes. The purpose and duration of the purpose of travel and the duration of the stay can't be such as to restrict the application of the scheme. My learned friend in the Upper Tribunal will say, look, it's not a strict interpretation because the CJU has said purpose and duration can't restrict the scope of the scheme. But our case has never been that we care why the customer is using a minicab. When I give my examples of getting me home from the supermarket, or picking me up from the nightclub, or taking me to my friend's house, I'm not appealing to the purpose for which I'm using a cab, i.e. to get to my hospital appointment or home from the supermarket. Those are just examples of the millions of routes whizzing across London point. And of course, the scheme isn't going to be limited to asking, well, travel agent, is your flight being sold to somebody who's going, as the Advocate General puts it, on a wine tasting tour of Spain, or is it being sold for somebody attending a funeral or for whatever other reason. Of course, purpose doesn't matter. But that purpose doesn't restrict the scope in that way doesn't support a broad interpretation whereby the concept of travel agents and tour operators are raised from the scheme as it is under the high-level approach. Just for your note, the Advocate General at footnote 21 also makes the point that this is exactly the sort of trader who actually needs the scheme, given it's doing this multiple jurisdictions, Germany and the USA, supplies. The stay in a host state, we say, should be understood to be that it's important that it's a stay abroad in that case. It adds to the similarities with a travel agent tour operator. And can I address the point my learned friend will no doubt make and the Upper Tribunal makes? But how can a stay with a host family or college accommodation be identical or at least comparable to the supplies of travel agents and tour operators? There's a complication about stay with a host family because Germany couldn't make its argument about the packages directive unless the stay with the host family was free. But putting that aside, dealing with the point head on, of course, travel agents and tour operators don't typically supply stays in a college accommodation with meals. But importantly, they do supply comparable supplies. If I'm a student, I'm going to study abroad, and I need somewhere to stay near my accommodation, I can get the college accommodation with meals from the college, or I can look to a travel agent to find me somewhere to stay. So the options are at least competing. Obviously, it's further than from the travel by plane, but that's what the CJU says, they're at least competing. And I'll just give you the note, we don't need to turn it up, but at page 408 is an old tribunal domestic case. And it's another foreign education programme supplier. And at 408 is just the application form that the students have to fill. So I'm not going to it for any sort of legal point, but the application form says, do you want to stay in a hotel or with a host family? And that's a real world example of how the two options are comparable and competing. Sorry, it's at page 409, the example, the real world example. And as I say, the travel agent sector isn't competing in that way because it's not offering me supplies that are identical or similar to Bolt supplies, and the FTT didn't find that they were. Now, the third case I need to go to is Alpen Chalet, and we say that each tribunal misunderstood our point about Alpen Chalet. We say Alpen Chalet, properly understood, contradicts the high-level approach head-on. To introduce the point, because it's slightly convoluted, there was a case, Star Coaches, where the CJU decided that resupplies passenger transport by coach, so the resupplies of passenger transport by coach in that case were not within the special scheme. And the apparent reason they gave for that was it's just coach transport, it's not multiple services. Stage one. Stage two, the Alpen Chalet case makes clear, and I'll come on to it, that you don't need multiple services. And so it has to explain, to reinterpret star coaches, and what it says about it at paragraph 32, but I'll take you directly to the paragraph, is, but in star coaches, there was no other feature that would make the supply identical to the supplies of travel agents or tour operators. And I say that the CJ, you couldn't have made that comment, couldn't have even tried to explain the rogue, as it were, star coaches result if the high-level approach were right. And my complaint is that neither tribunal considered that point and got caught up in what is a subcontractor. So I'll take it as briefly as I can. If we start with star coaches, which is on page 231, so paragraph 8. Star Coaches is engaged in the transport of persons by coach in the Czech Republic and between member states, operates that transport either with its own coaches, leave that aside, that's the in-house supply that's not being considered, or by using subcontractors, which are transport companies whose transactions are subject to VAT. Its customers are exclusively travel agents established in the Czech Republic or in other member states. And then, so we have the chain, the VAT chain in this way. Coach Transport Company supplies its coach services to Star Coaches. Star Coaches supply the coach services to their customers, the travel agents. The view to the travel agents supplying it to their presumably end user customers. And the term subcontractors there is getting at the fact, again, just as with the airline and the peanuts, that when Star Coaches buys in the coach transport and provides it and sells it on to its travel agent customer, it's using its supplier, the coach operator, as also its subcontractor, i.e. it's entrusting performance of the supplies and services generally associated with those supplies to that subcontractor. Now, turning over the page, you see at 21, the test as I put it. Moreover, the court has considered that regardless of the formal classification of the economic operator, the underlying reasons for the scheme are equally valid where the operator is not travel agent in the normal sense of the word, but in the context of another activity affects identical transactions to theirs. That's my test. But then, again, just to avoid the detail, the court this is a side story we don't need to get into, but the short point is it misinterpreted Van Ginkel to be saying, when in Van Ginkel some hypothetical example was being discussed, that you do need a second service. And then at 26 we see the conclusion. A transport company which merely carries out the transport of persons by providing coach transport to travel agents and does not provide any other services such as accommodation, tour guide or advice does not affect transactions falling within the scheme. That's wrong, as in if you take the reasoning on its face, it's wrong because we know you don't need multiple services. And now if we could turn to Alpenchalet to show the court how it deals with the problem of star coaches. So, turning to Alpenchalet, it's page 351. If I could briefly outline the facts of Alpen Chalet. Alpen Chalet bought in accommodation in Germany, Austria and Italy and made sales of holiday rentals to its customers, and at paras 12 and 19 is described as a travel agent. And in some cases, that accommodation included the cleaning, laundry or bread roll service. And the question was, where it was just the accommodation, the holiday accommodation, could that be in the scheme? Or could you only get in the scheme if you had the bread roll, laundry service or some other service? The multiple services question. And again, taking it a little quickly until I get to the key point. At 20 to 24, there's a setting out that it has to be a resupplier buying in and selling on. Alpen Chalet ticked that box. Then the characterisation of the travel agents being the sector in the scheme. The CJU then considers previous case law on the question whether a single service of holiday accommodation is enough. And we see at 27, it discusses my travel. That's the case where there had to be this apportionment and the extracting of in-house supplies, which recognised that a flight alone was sufficient. Then it outlines the IST case, saying, this is paragraph 28, in return for a package price, in addition to services associated with language training and education, which IST supplies itself, that's the in-house element of the supply, services brought in from other taxable persons, such as travel to the host state and or the stay in that state, the term and or demonstrates one of those services can be sufficient. So you don't need both. It could have been the travel by plane or the stay in the host state, summarised here to highlight that it's one or the other. Then the Minerva case, and then we get critically to the star coaches problem, which seemed to say that you need more than one service. I'm reading from 30. The order in star coaches doesn't enable a different conclusion to be reached. First, the court clearly confirmed the case law stemming from the judgment in Van Ginkel. Second, the court merely noted in that case that the transport services provided by a trader cannot be covered by Article 306, where they are provided, I could insert a little A there, where they are provided A, through a subcontractor, not to the traveller himself, but to travel agents, and please insert little b, that transport operator does not have any other feature which is capable of making its supplies comparable to those of a travel agent or tour operator. Now, it's hard to understand lim A of that paragraph because, as I showed the court, in commission in Spain, it had been established that traveller can include customer, i.e. supplying to a travel agent can also come within the scheme, but that point hadn't been established at the time of Star Coach's decision. And the tribunals, we say, misunderstand what is a subcontractor, and they say that the reason Star Coaches, what it's saying here is that Star Coaches was a subcontractor, when clearly we see it's acting through a subcontractor. But my major complaint is they don't deal with lim B. In a chain transport operator to, coach operator, to Star Coaches, to travel agents, to end user, i.e. resupplies of passenger transport, if the high level approach is right, how does the CJU feel able to say it does not have any other feature which is capable of making its services comparable to those of a travel agent and tour operator? I say it can only say that because my interpretation of Majid and IST is the right one. And my complaint is the tribunals below didn't consider that limb B, and we say therefore failed to see the importance of Alpen Chalet in supporting our interpretation of the scheme.
So as I understand it, you say that this reasoning necessarily rejects the high level approach,
Yes.
essentially.
And I should just say the answer obviously given in, so I'll take it slow. It endorses, we say, the reasoning in paragraphs 20 to 22 of Magit and 22 to 24 of IST. The paragraphs that
Sorry, give us the paragraphs
Yes.
again. 22.
20 to 22 of Magit, as repeated in 22 to 24 of IST, and which we say are the paragraphs setting out the key test, and are the paragraphs that the Upper Tribunal said, well, they're not really about the test. The test is those general words,
Yeah.
trader. And before I leave Alpen Chalet, the answer, of course, is at 35. Yes, the holiday accommodation could be in. And the second point made in Alpen Chalet is, sorry, Alpen Chalet, you lose the reduced rate. Because once you're in the scheme, the reduced rate you would have otherwise enjoyed, because there's a reduced rate applying to holiday accommodation, is lost. The point I made at the outset, that it's not, that one, when carrying out these judgments, one has to keep in mind that it's that there are other provisions and also other kinds of supplies to keep in mind. Don't think I need to go to Director Kratovich. I'll just make my point very quickly. That was what's called a hotel consolidator service provider. It was a bed bank, buying in bulk hotel rooms, supplying them to hotel rooms and supplying them to travel agents to supply on to customers, presumably. But in any case, unsurprisingly, the CJU said, look at Alpen Chalet, that single service is sufficient. For good measure, I think it points out in paragraph, I think it's 29, it points out, in fact, because there are supplies abroad in multiple locations, an appeal to the purpose. Hotel Services Consolidator was in the scheme. I say completely unsurprising. It's hotel rooms, paradigm instances of travel agent supplies. And the final case to show you is the most recent CJU judgment, Dragaram. It's page 389. So Dragaram was a travel agent in Romania who bought in airline plane tickets for flights inside the EU, sold them to end users. It didn't charge VAT. And the reason it didn't charge VAT is because it sought to rely on what Romania in particular had been allowed to do on entry into the EU, which was it could continue to exempt international passenger transport and that's explained, that's set out in paragraph 7 and 8 of the judgment. Dragaram was assessed on the basis that it came within the scheme. And Dragaram sought to rely on Romania's rules, which permitted an escape, it said, from the scheme as long as it didn't supply other tourist services. So the question again for the CJU was the resupply of plane tickets within the scheme, and could Romania allow Dragomar to keep them out on the basis that it wasn't supplying other tourist services? And again, I'm just going to paraphrase the key paragraphs. 27, setting out of the special scheme of travel agents, and it derogates from the normal VAT scheme. As an exception, it has to be interpreted only to the extent necessary. 28, the essential aim is it applies to travel agents to avoid difficulties they would have under the normal rules, such as to obstruct their operations. 32, a single supply of accommodation is sufficient. Travel agents don't need to look at the constituent elements and apply some inside the scheme and some outside. And then 33, it can therefore be clearly deducted, it's deduced, this is an unofficial translation. It can therefore be clearly deduced from this case law that the sole supply of passenger transport services bought from taxable third parties by a travel agent for its customers falls within the scope of the special VAT scheme for travel agents, regardless of the fact that the supply is not accompanied by additional services. Under these conditions, the answer to the question as meaning that the supply of a taxable person of airline tickets purchased from other taxable persons and sold on ... is in the scheme. I go to that because my learned friend will say, well, look, it says passenger transport and it's speaking in general terms, but it's not a case where it's looking for identical or comparable supplies, because travel agents paradigm supplies of the plane tickets, and it's set out the object of the scheme and that it's targeted the travel agent sector. So we say that that doesn't undermine anything I've said so far. And then at 37 for your note is the other point I made. Dragoram can't use the exemption that was given to Romania. Entry into the scheme is one my clients put it, entry into the black hole. You lose the zero rate, you lose your reduced rate, you lose any exemption.
Sorry, so you say it doesn't, to what extent do you rely on the fact that it wasn't actually a travel agent in that case? You say that means they don't need to deal with the identical or comparable?
Well, they're not dealing with it. The question there was that single supply was enough, so you can't read into the fact that it's...
So you say they're just not addressing the question in this case?
I'm just trying to paint a complete picture, and I think I've taken your lordships and ladyship to all the cases.
Well, the whole premise of the case is, as we see from paragraph 13, is that Dragoram Tour is a travel agent. So that's the starting point.
That's my...
And then the question is, does it matter that they are essentially providing a single supply? But on that single supply point, can I ask you this question? We see in paragraph 18 a description of what they actually did. And we see the reference to booking assistance, advice, information services, travellers, booking management on platforms, services planning for travel itineraries. And so that all seems to be then encapsulated in the phrase that's put into question 3, information and advice. And so when the court is answering the second and third questions, so including the third question, they keep on reiterating the formulation, not accompanied by additional services other than information and advice services. So we see that in 25, it's referred to again in 29, and repeated almost verbatim in 33 and 34. So what do you say about the repeated reference to other than information and advice services?
Sorry, my lord, can I just take a second to make sure I've understood the questions? So if I take 33, which is the conclusion.
It's not necessarily a point against you.
So 33 is the conclusion, and it's been put to me that it repeats points made earlier in the other paragraphs anyway. So looking at 33, it can therefore be deduced sole supply of passenger transport brought in or supplied by a travel agent for its customers is within the scope, regardless of the fact that the supply is not accompanied by additional services, or that the agency also provides information and advice service to its customers. So it's saying the plane tickets are on their own enough. And if the plane tickets weren't enough, anticipating something my learned friend may want to say from her respondent's notice, if they're not enough, advice or a free blog on Bolt's website isn't going to get you into the scheme.
Yeah.
And the reason there is this theme is occasionally, I wanted to avoid the derailment, but basically Van Ginkel gave a hypothetical example of, well, travel agents in any way, it is multiple services in the sense that they give advice. But his main conclusion was you didn't need multiple services.
So put
that's
it
picked
another
up.
way, this case isn't relying on the fact that information or advice is offered on top of the plane tickets.
No.
It says it doesn't matter, but your point is they're just not focused on the question that we have to consider in this case, which is the fundamental nature and whether it's a travel agent type service, as you say it has to be. You say that point just didn't arise because the only point is the single supply.
Yeah. And it's described as passenger transport by a travel agent.
So you don't need additional services, including you don't need information or advice.
Yes, agreed. But I make a further point. If you don't have the right kind of service, having a free blog on your website, as Bolt has, that sets out the delights of Edinburgh, or the fact that you have a helpline so your customers can contact Bolt. I think the evidence was primarily for payment issues, but in any case, my main point is if the main service, if I'm right that the minicab service, the passenger transport isn't in, pointing to this free blog and so on isn't going to get you in. No, neither tribunals decided that, but what the FTT said is if you need multiple services, then the free blog and the 24-hour helpline has it. But of course, CJU case law is clear. You don't need multiple services. And that's why I make the further point. Having a free blog and on the website and a customer helpline isn't going to make your services identical or similar to a travel agent if they're not otherwise, if they're not already. Does that answer my landlady's question?
Thank you.
That's all I wanted to say on the case law. My lord, how am I doing for time? Just so I can prepare over lunch, cutting things down.
Well, you seem to have done very well as far as I can see.
Okay. Would it be best if we stopped 3 or 4 minutes before so I can start fresh on the FTT and Upper Tribunal decision and come back 5 minutes earlier? Obviously, it's not.
Okay.
Would that make sense?
Let's do that. We'll see you at 1:55.
Court
My
rise.
lord.